coffee break webinar in our Rural Dispute series. My name is Elaine Brailsford and I'm joined by Stephanie Hepburn.
Hi.
Today we are going to be looking at wildlife crime and livestock worrying, some proposed changes in the legislation and what remedies may be available when these occur. Looking firstly then at livestock worrying. In December last year, the Scottish Government published findings from survey research on livestock worrying. With an estimated 7,000 incidents of sheep worrying in the period May 18 to 30th April 19, incidents of livestock worrying are on the rise. The total estimated cost of dog attacks across Scotland each year has been estimated at around £5.5 million. So the devastating effects of livestock worrying for farmers and their businesses is clear.
So what's the law around livestock worrying? Well, the Land Reform Scotland Act 2003 makes it clear that any dog walker exercising access rights under the Act, commonly known as the right to roam, must keep their dog under proper control. Proper control is not defined in the Act, but the Scottish Outdoor Access Code provides practical guidance for dog walkers, which landowners should be aware of. I won't go into these in detail today, but a link to the relevant section of the code is in the resources section of the webinar. The first thing to do then, if you come across a dog walker acting in breach of the code, is to advise them of the breach, and that might be enough to prevent further worrying.
If a dog is found to be livestock worrying, the owner or person in charge of the dog could be found guilty of an offence under the Dogs Protection of Livestock Act 1953. Livestock worrying is currently defined as attacking livestock, chasing livestock in such a way as may reasonably be expected to cause injury or suffering, or being at large, not on a lead or under close control, in a field in which there are sheep, without the authorisation of the owner or occupier. So where there is sheep worrying, a report can be made to the police so that they take appropriate action, although the proportionate thing to do in the first instance, as Stephanie has said, may be to point out to the dog walker the code and see if that will curtail the behaviour. Where someone is found guilty under the 1953 Act of failing to keep a dog under proper control, the court may impose a fine of up to £1,000. Local authorities can also issue what's called a dog control notice, and that's under the Control of Dogs Scotland Act 2010. And that notice can impose a range of measures, such as requiring the owner to keep the dog on a lead at all times, or to have the dog muzzled when in public places. And breach of a dog control notice carries with it a maximum fine of £1,000. The Animals Scotland Act 1987 also imposes strict liability for injury and damage caused by dogs biting, savaging or harrying. And strict liability means that the person in charge of the dog is liable for the injury or damage, even if there was no deliberate or reckless conduct on their part. And compensation may also be payable to the affected party.
Prevention is better than cure though, so practical steps like putting up signs, alerting the public to the presence of livestock and reminding them to keep dogs under control should always be considered if worrying is a concern. Unfortunately, no practical step provides a guarantee against livestock worrying, nor does a police investigation or the issuing of a dog control notice happen immediately. Where immediate action is required, for example, if a dog is actually attacking sheep, the farmer or the landowner has the right to detain the dog to prevent it causing injury or damage. But if they do this, they must then take reasonable care of the dog and return it to the owner or advise the owner or the police without delay. As a last resort, the Animals Scotland Act 1987 does give the power to shoot a dog, but this can only be done for the protection of the livestock. And where the dog is actively worrying or attacking the livestock and there's no other practical means of ending the attack. And Elaine is now going to outline some proposed changes in this area.
In response to a steady and continued increase of reports of cases of livestock being attacked by dogs, the Livestock Worrying Dogs Protection of Livestock Amendment Scotland Bill has come before the Scottish Parliament and it's currently out for public consultation. The bill seeks to amend the current law and in particular the 1953 Act that I mentioned earlier. Now, key features of the bill are a proposal to increase the maximum penalty to a fine of £5,000 or imprisonment for 6 months. There's a proposal to allow the courts to ban a convicted person from owning a dog or allowing their dog to go onto agricultural land on which livestock may be present. There's a proposal to give the police greater powers to investigate and enforce livestock worrying offences, such as going onto the land to identify a dog and to seize it and collect evidence from it. There's also a proposal to allow the Scottish Government to authorise bodies other than the police to be given investigation and enforcement powers. But it's not clear what these bodies that the government might authorise might be. Livestock would be redefined to reflect the extended species now farmed in Scotland. So it will include llamas, alpacas, ostriches, farmed deer, buffalo and enclosed game birds. And to widen the definition of worrying to include chase, attack and kill in order to make the offence clear and allow people a better understanding of the term worrying. Now, the consultation deadline is the 28th of August this year, and we've included details of the consultation and how to respond, if you wish, in the resources section of the webinar.
So moving on now to wildlife crime. This encompasses both the very evident illegal and harmful activities like badger baiting, raptor persecution and egg collecting, to the not so obvious like inappropriate disposal of chemicals, fly tipping and the introduction of invasive non-native species. And here the body charged with enforcing the law in this area is Police Scotland, so we're looking at criminal wrongs rather than civil wrongs. The latest wildlife crime in Scotland annual report was published in December 2019, and in financial year 17 to 18, Police Scotland recorded 236 reports of wildlife crime in that period, so a rise on the previous report of 6. So it's clearly an increasing concern in the countryside, and Elaine's going to touch upon the law in this area.
Well, the Wildlife and Natural Environment Scotland Act 2011, commonly referred to as the Wayne Act, updated the law relating to the protection of the rural environment, including the Wildlife and Countryside Act 1981. There's so much we could talk about in relation to wildlife crime, but
the whole series in itself of webinars.
Well, it is. But the change brought into effect by the Wayne Act that has received the most attention, and which is what we're now going to talk about, is the introduction of the concept of vicarious criminal liability. Now, some of you may already be familiar with the concept of vicarious liability in a civil context. For example, an employer may be liable for the negligence of his employees. However, Section 24 of the Wayne Act introduced Sections 18A and 18B of the Wildlife and Countryside Act 1981. And that provides that a landowner, shooting business or manager can be held criminally liable for the actions of their employees, contractors or agents who are under their management or control. The introduction of vicarious criminal liability means it's now very clear that landowners and managers must take a proactive role in land management if they are to escape a criminal vicarious liability conviction. And Stephanie is going to use a practical example now to demonstrate how this works in practice.
So if we take an example of a large estate, let's call it the Shetwed estate, that's owned by Elaine in our example. Elaine hires a gamekeeper called Sam to manage the shootings on the estate, but no employment contract entered into with Sam. Sam tells Elaine the raptors are predating on the eggs and the young pheasant he is rearing for shoots. And Sam is keen to take matters into his own hands and trap the raptors. It's an offence to intentionally or recklessly kill, injure or take any wild birds, so obviously Sam can't just trap the raptors. Nonetheless, a dead trapped raptor is found on the Shetwed estate and Sam has been arrested by the police. If it can be established that Sam did set the traps, he'll be found criminally liable and he may face up to 6 months in prison or a £5,000 fine, or both. But what about Elaine's exposure to liability? Elaine needs to know what will happen to her if it transpires that Sam did set the traps which killed the raptor, and whether she herself might be liable. So vicarious criminal liability applies to the following offences: the killing, harassing, taking or disturbing of a wild bird or its nest, the setting of traps, poisons, or the use of other prohibited methods of killing or taking, and the use of pesticides containing one or more prescribed ingredients. So if Sam is found to have set the traps, then Elaine, you may be vicariously liable. Attempts to commit these offences are also included.
And does Sam have to be prosecuted before they'll come after me?
No, so proceedings may be taken against you, Elaine, whether or not they're also taken against Sam. So one or other or both of you may be prosecuted.
Crikey. And might I escape vicarious liability because he's not my employee?
No, unfortunately not. So vicarious liability does not just apply to actions by employees, but also covers the case where someone like a gamekeeper is carrying out relevant services for somebody else, Elaine in our example. And carrying out relevant services is defined as managing or controlling any of the following. Firstly, the operation or activity of killing or taking any wild birds on or over that land. Secondly, the habitat of any such birds on that land. Thirdly, the presence on or over that land of predators of any such birds. And fourthly, the release of birds from captivity for the purpose of their being killed or taken on or over that land. And the person for whom the relevant service is carried out, so Elaine in our example, must have a legal right to kill or take a wild bird on or over the land, or as someone who manages or controls the exercise of any such right. So if Sam is providing the gamekeeper services by arrangement between him and Elaine, then Elaine won't escape criminal vicarious liability just because there's no employment contract in place. It's also worth mentioning that even if Sam was providing the services by arrangement with some other person, who is in turn providing the services to Elaine, or Sam's an employee or agent of that person, then Elaine may still be vicariously liable for Sam's actions. So the link between the actual person who may have carried out the crime and the person who may be vicariously liable may be through a third party. So these provisions could also apply to sporting and farming tenants maybe, who are providing a relevant service for the landowner, as well as less formal arrangements where an employment contract maybe hasn't been entered into.
And what penalties am I looking at if I am found to be vicariously liable?
So the maximum fine is £5,000 and it's up to 6 months in prison or both, which is obviously quite severe.
And what about my defences? I mean, I didn't know Sam was going to go and do this.
Yeah, so ignorance isn't bliss, unfortunately. Whether Sam's an employee, an agent, or a contractor, to avoid liability, Elaine, you must show that as well as being unaware of the offence being committed, you'd taken all reasonable steps, and it's all, not any reasonable steps, and due diligence to prevent offences being committed on your land. So the more precautions you put in place, the harder it's going to be for a guilty verdict to be brought against you. Things like putting a requirement to comply with all statutory obligations and refrain from any illegal activities in your contracts or leases, whether it's with employees, agents, contractors or tenants, will be important. Obtaining references, looking at training, risk assessment, and things like that will also be relevant. I've put a fuller but non-exhaustive list of steps you might take in the resources section of the webinar. It's really an objective test, and what's reasonable is a matter for the courts to decide. It is a question of fact and degree in the particular circumstances of the case, but I think given that it's all reasonable steps and not just any reasonable steps, it might be quite a difficult practical hurdle to overcome.
I would think so.
Mm-hmm.
So looking briefly at legislative changes, on the 30th of September last year, the Animals and Wildlife Penalties Protection and Powers Scotland Bill was introduced. And this bill is also currently going through the legislative process. And the bill aims to increase the sentences for a significant number of wildlife crimes, including those relating to birds and eggs, badgers, deer, and the hunting of wild animals with dogs. For the majority of these offences, the maximum sentence would increase to a fine of up to £40,000 and or imprisonment for 1 year. So we'd better hope, Stephanie, that Sam behaves himself, I think. For those offences considered by the Scottish Government to be the most serious, such as those involving the injury or the unlicensed killing or taking of wild animals, the maximum sentence would be increased to 5 years imprisonment and or an unlimited fine.
Yeah.
In addition to these stricter measures, the bill also seeks to deter wildlife crime by introducing fixed penalty notices. Effectively, these are spot fines that would be administered to those guilty of a wildlife crime as an alternative to criminal prosecution. And it's yet to be determined what offences would be covered by these notices, but likely I would think to be the more minor offences and those which do not cause an animal to come to harm. Well, time's up yet again. If you have any queries about our webinar today, please contact us. You'll find the note Stephanie referred to on our resources part of this webinar, but we'll also be updating the note with these legislative changes. It'll be on our website, I think, in the next week or so. So please keep an eye on our website. Next week, it's Hamish's turn. He's up and he is going to be speaking about contract farming disputes. Hope you'll join us then. Thank you very much.
Thanks. Bye.